This is about chapter 3, the Recording Act. So, essentially, under this chapter, we're going to talk about the various aspect of how the recording is done, and essentially towards the land ownership and the land ownership. So, land ownership can be acquired by inheritance, deal, a deed, agreement of sale, mortgage remedy, court order, and also by the act of possession. And again, grant is a legal term used in the deed of conveyance to indicate the transfer of interest or an of transfer interest in the real property by the grantor to the grantee. And again, in the deed, there's a deed of conveyance. Essentially, it is basically assigning or giving the ownership of a real property to from one person to another person. The next item is regarding the quit claim deed. Essentially, quit claim deed is a document wherein a person agrees to release any right he or she may possess in the parcel of land. Now, in case of a mortgager or the borrower, the release involves the equity of redemption. A quit claim deed can be an expedient process where the mortgagee and the mortgager arrive at the conclusion that there is no practical way in which a mortgager can keep the property. This approach is usually quick, inexpensive, and more pragmatic way in the resolution of otherwise an awkward situation. A quit claim deed does not involve either covenants and undertaking and is simple relinquishing of whatever right or interest are vested in the mortgagor. If an equity exists, the mortgagor will potentially be bargain with the mortgagee for the payment to satisfy the equity in return for giving the quitclaim deed. Essentially, a quitclaim deed is more easily affected if no other encumbrances exist on the title. Otherwise, action may have to be taken to remove such interest in the property through other remedies, or the mortgage may elect to assume a mortgagee may elect to assume these encumbrances. Even in the absence of any equity, this approach may prove best given time and cost consideration. However, mortgagee, in accepting the quitclaim deed, not only acquires the right concerning the property but also any problems associated with it, and has no further recourse against the mortgagor or the borrower. Now, in terms, let's look at the registry system. Registry system is an old system in for land registration in Ontario. The new one is a Land Title Act, which is more prompt and more accurate registration to clearly indicate the interest in the land. But the registry system is old since 1975. And again, the way registry system works is it records title document on a geographical basis. A separate record is kept in the abstract book for each lot and or the part of the lot of land as originally patented by the crown and appears to be to any registered plan of subdivision or other type of registered plan. Given the growing complexity of the real estate interest, this indexing system has grown to include a wide range of abstract books involving condominium, subdivision plans, leasehold, wills, probate, highways, and the lot sundry lots. Given inherent weakness and complexities in the registry system, property record throughout Ontario are being converted into land titles. So and so there are a few key items here: abstract book, adverse possession, and the chain of titles. So an abstract is written history of title, but not assurance of the good title to the parcel of real estate as recorded in the land registry or land titles office. So the or abstract pages include a condensed history of the title to individual parcel of land and includes a synopsis of all recorded instruments affecting the title, deed or transfer of land, mortgage, discharge of mortgage, encumbrances, easement, and restrictive covenants. Abstract pages have undergone modifications in format or information required and method of recording within provincial jurisdiction utilizing the registry system. An abstract book is a central reference source within a registry system. Historically, these books began as a compilation of patented lots in a numeric order by lot and concession, but ultimately expanded to include a variety of books, including subdivision and condominium. Individual ownership was detailed as by the way of abstract book within the wide range of abstract books. The term abstract and abstract books are more commonly associated with the registry system. During the past decade, cumbersome abstract books and associated manual recording system have given way to computerized record keeping. Adverse possession arises when an individual, not the owner, takes possession of the property hostile to and without consent of the owner and remains in exclusive possession, using the land like an owner and ignoring the claims of other person, including the owner. It is possible by adverse possession for an occupier of the land to extinguishing the title to the owner. The possessor then becomes, in effect, the owner of the land. Title by adverse possession began in medieval times, given the number of large estates and the fact that the absentee landowner and squatters often entered and stayed on those lands for long periods. With the introduction of more accurate surveys, the number of squatters have become smaller. Under the common law, a person can acquire a possessory title to the land under certain circumstances by taking possession of the land for a period of time, as set out in the applicable provincial law of limitations. The possession must be open, exclusive, and continuous for a period without the consent of the owner, but with the owner's knowledge. Adverse possession ceases to be effective if interrupted by owner during the limitation period, before the limitation period has elapsed, or if the adverse possessor abandons the land before the limitation period has expired, as the law considers the possession has returned back to the owner. Practitioner must exercise caution in all matters regarding reverse possession, as background possessory title in Ontario is only granted under the Registry Act. No title by reverse possession can occur in the land titles. In Ontario, for those areas under the registry system, statutes set out limitation period beyond which the owner loses the right to regain possession of his other land. That period set out in the Limitation Acts is 10 years. The principle behind the law of limitation is that the person who has a right of action against another must pursue it within a time period or lose the right. He or she must not keep the other party indefinite jeopardy of being sued. Again, the chain of title is is a sequence of conveyance or encumbrances affecting the title pursuant to the applicable history, registration within the provincial jurisdiction. So, so the term chain of title is most commonly associated with the land registry. Practitioner may refer to a history record for 40 years period. Practitioner may refer to the history for record for 40 years period. So coming to the land titles, the first Land Titles Act was passed in 1885 with limited exceptions. All provincial crown lands must now be registered under this act. In addition, all lands to be subdivided by a registered plan of subdivision, and all lands on which condominium are developed under the Condominium Act must be registered under the Land Titles Act. If the system of land registration is available in the applicable land registry office, land registered under the Registry Act may be brought under the land titles by the owner through a process called as the first application. So essentially, it's a way of bringing the land from the Registry Act to the Land Titles Act. Large-scale conversion of registry records into land titles have been underway in the province for last several years. The land title conversion process involves the conversion of registry record to land title coincident with the move to the electronic registration system. Practitioners increasingly rely on land title searches as the land title conversion extends beyond the urban centers, while registry operates under the track indexing system using geographical location. All land titles centered are by the way of assigned parcel numbers. A separate parcel record is kept in the register of titles for each unit of ownership. The actual title searching process involves identifying outstanding entries in the most recent title register, the most recent parcel register for the specific property. So the key here is that a title searching is not looking at all the records, just involves searching, identifying outstanding entries on the most recent parcel register. So, regarding the features and principles, a method of government registration of titles to land in which the government, subject to certain limitations, that guarantees the title and operates under the registration process. So, one of the features of the land title system is it is guarantees the government guarantees the title. All transaction must be registered against title in provincially operated land titles office. And certificate of title is intended to be complete and accurate reflection of the result of all preceding transactions affecting the affecting the affecting the property. So so once you have a certificate of title, it's all you need to claim possession to that property. An assurance fund is also provided in case of any errors, or in case a person suffer loss due to errors and omissions of the register. And no title to the land register under the act is adverse to title of the registered owner. Each parcel of land is recorded in the register or at the land titles office as a unit of property. The land is surveyed and accurate boundaries and the parcel descriptions are available that facilitate recording of land disposition. A land title office is officially referred to as the land registry office for the land title division of the regional municipality of or county of name. Each land title division is overseen by a land register. The act provides for documents to be effective on registration, that priority of registration prevails. The land register page is abstracted, and therefore examining the actual register document is usually necessary to gain proper perspective on the extent of ownership. Land registrar is empowered to make rulings as to the sufficiency of documents subject to certain avenues of appeal. Detailed uniform procedures must be followed in the preparation of all documents, either manually or electronically, for registration under the land titles. The land title system operates under three principles. There's a mirror principle, collateral principle, and the insurance principle. The mirror principle says that the register of title is a mirror that accurately and completely reflects beyond all arguments the current fact that are material to the person. The mirror, so essentially, whatever is there on the ground is what has to be reflected back. That's the mirror principle. The curtail principle says that the register is the sole source of information for the proposed buyer, who need not and indeed must not concern themselves with the trust and equities that lie behind the curtain of information. The insurance principle is that the mirror register is deemed to give the absolute correct reflection of the title, but if a human error or a flaw appears, anyone who suffers loss must be put in the same position so far as the money can do that he would have been had he been the true owner. So the land title is divided into few parts. Part 1 is the preliminary definition. Part 2 is the organization and administration. Part 3 is jurisdiction of the court. Part 4 is the application for first registration. Part 5 is the assurance fund. Part 6 part owners. Part 7 subsequent registration. Part 8 description of land and register plan. Part 9 deals with the fraud, and Part 10 deals with the ratification of register regulation, and Part 11 deals with the regulation and procedures. So let's talk about the land title assurance fund. So this is a part of the Part 5 of the Land Titles Act and provides the person deprived of the ownership through selected errors and fraud to be entitled to compensation, provided such compensation cannot be obtained from other sources. The compensation is subject to various qualifications. The person claiming to be entitled to payment for compensation must apply to the Director of Titles. The amount of compensation will be determined by the Director of Titles, subject to certain rights by the claimant. So, an important piece of legislation is the Land Registration Reforms Act. So, essentially, Part 1 of the Land Registration Reform Act is devoted primarily to the implementation of the standard registration documents for both registry and land titles. There's a Form 1, which is the transfer deed of land. Form 2 is the charge or mortgage of land. Form 3, discharge of mortgage of land. Form 4, document general. And Form 5 is the schedule. Part 2 is for the authorization of, automation of records and property mapping, including the storage and retrieval of such documentation. Part 3 is outlines the procedure for electronic registration, including the use of electronic format, and it also sets the stage for various regulations relating to the conversion of land registration record into an automated format. So, so let's look at the transfer of deed form, which is a Form 1. This is a standard form, also referred to as Form 1. It's used to register a deed under either the registry or land title system. The standard forms are introduced in mid-80s. So essentially, the transfer deed is normally registered along with the land transfer tax affidavit. Practitioner may encounter a deed or transfer of land when reviewing instruments concerning title to the property. This form is used to convey titles and interest in real property and includes full name of both seller and the buyer, along with the birth dates. Any other person who has an interest in the real estate being conveyed also joins the document. The third parties, such as life tenant, spouse, releasing matrimonial home, possesses right, and he is to ben to and he is a beneficiary of an estate. So there are a bunch of implied covenants. So Section 5 of the Land Registration Reform Act sets out the implied covenants for transfer of freehold or a leasehold land by the transferor. Additional covenants apply to the release by a trustee or also even a settler. Only freehold covenants are included below. The seller right to convey the land and the buyer's right to quiet enjoyment. Assurances by both sellers and buyers to execute such further assurances and to such other act as may be reasonably required. Assurance that the seller has not done or omitted or permitted anything whereby the land is or could be transferred and encumbered. The seller transfers to the buyer all existing claims that he or she has upon the land, except as noted in the land registration record. Implied covenants can be changed through an through an amending schedule. When the deed of or transfer subject is submitted for registration accepted by the land register, the transaction is said to be closed and completed. Ownership normally changes at the time, and typical possession and payment occurs simultaneously, unless otherwise provided in the agreement of purchase and sale. The charge of mortgage of land is a standard form used to register a mortgage under either the registry or land title system. Standard forms were introduced during the mid-1980s. The charge of mortgage of land provides important information for the practitioner concerning mortgage financing on property being listed or sold. So again, the box 4 sets out the principal amount of the mortgage that was originally placed on the property, and box 5 sets provides the legal description of the mortgage property. Box 7 outlines the type of state, or whether it's a fee simple, leasehold, and box 8 identifies the standard charge terms that apply to the mortgage between the mortgage and the mortgager. The standard charge terms provide detailed terms of the mortgage and sign a number in the land registry office when filled. Box 9 outlines the payment provisions, including the last payment. A balance due is provided, as Canadian mortgage typically have long amortization period combined with the shorter terms, resulting in the balance due amount and the appropriate ballooning payment as required. Box 10 provides for any special provisions agreed between the mortgagee and the mortgager. Some of the implied covenants with these forms are essentially grouped into three categories. There is the first implied covenant, second implied covenant, and third implied covenant. The first implied covenant says that the mortgagor will make payments, including interest, and also pay taxes. The mortgagor has a legal right to give the mortgage. Uh, the mortgagor will provide insurance on the building. The mortgagor has no other encumbrance other than those currently registered in the specific on the specific property. The mortgagee, when the mortgage is in default, has the right to take possession, collect rent or profits, and sell the land. Mortgagee is in possession by default, should be granted quiet possession. Upon default, the total money is due shall become payable. Interest in areas may be collected. The mortgagor in default agrees to do such things as reasonably requested by the mortgagor in possession relating to the land. The mortgagor covenants that the land held in fee simple is owned in good title. The mortgagor covenants that the lease is valid and up to date, and further that the reimbursement to the mortgagee will be made by the mortgagor for non-payment and non-performance of other covenants under the lease. Now, there's again standard charge terms when reduced under the Land Registry of Reform Act of 1984. The Act provided that effective April 1945, a person or corporation has the right to file standard charge items with the Land Register. The Register assigns a number for this unique set of charge items and circulates the set to all Land Registry offices. This number can then be included in charge or mortgage of land, and mortgage is deemed to be automatically include these set of terms. Standard terms, charge terms can be amended by filing a new set with a new number. In reality, a mortgage may have several set of standard charge items registered with the land register at any particular point in time, each with a unique reference number. Should any information within the set of standard charge items conflict with the charge or mortgage of land, then the latter will prevail. If a specific prepayment or other privileges are inserted in the appropriate space provided in the mortgage form, those are also preempt any charge outlined in the set of standard charge items. The director of land register can require filing of standard charge items in electronic format as well. Now there is also a discharge of charge or mortgage, and there is a document general form. A, a document general form is used in a variety of circumstances, say with the property titles like caution, notice of lien, discharge of lien, power of attorney, judgment, notice of survivorship. Any document general registered on the title should be carefully analyzed, as the content can significantly impact the title to the property and consequently buyer and seller. Document general is relatively straightforward to read, and as either the provisions are fully described in box 8 or a schedule is attached. So now let's look at the next section, which is the land description. So the land is described for legal purposes in a precise manner according to the formula, so that one piece of land cannot be mistaken for another. As such, the difference between land description and a legal description are somewhat blurred. So again, there are three specific areas that we need to talk about. One is a lot of concessions. Second is township, and third is the measurement. The basis of a modern method of land description lies in the original survey of province completed in 1792. At the time, the governor Simcoe divided the Ontario into counties. He had a team of surveyors to trek through the bushes to mark out the actual boundaries. So essentially, the county boundaries followed the lakes, but in most cases were a straight line through the bush. The counties were then divided into smaller parcels referred to as a township. Each township was square. All the topography sometimes necessitated a rectangle or an irregular line on one or more township size due to the natural boundaries. Each township was in turn divided into strips of land called concessions, numbered in Roman numerals beginning with 1. Each concession was separated from the next one by road allowance. The road allowance were not always converted into actual road but remained as a public property. Each concession was further divided into lots running at right angles to the concessions and numbered in Arabic numerals from 1. The lots are sometimes divided by road allowances, each every fifth lot, simply or by lot line. So a parcel of land would generally be described as a lot 5 in concession to in the township of any town in the county of any country. With regards to that township, there could be single front township, double front township, or sectional township. A single front township is the oldest township system laid out in southern Ontario between 1783 and 1818. So the size of the lot in this system varied from time to time. The lots were intended to be 20 chains by 100 chains, and to contain about 200 acres. A standard road allowance of one chain. The standard road allowance was about a chain. Regarding the double front township, refers to a township where the original survey laid out the township into lots of 30 chain by 66.67 chains, and were usually half lot containing are usually patented in half lots containing 100 acres. The township boundaries and center of line of the road allowance between the concessions were run with spot planted on each side of the road to mark the front corners of the lot. As with a single front township, no provisions existed for check ties across the concession in the original survey. Thus, the road allowance between lots, when later surveyed, was usually found to jog at the front of the concessions. The section township was 1,000 acre sections, and lots were designed to be 20 chains by 50 chains and to contain 100 acres. The system of what was the first township system in which the attempt was made to check the survey by means of cross ties between concessions. So essentially, the single front township are 20 chains by 100 chains, and usually it's 200 acres, and with the road allowance, so one chain. Now the double front was like 30 chain into 36.67, 30 chains into 66.67, which is a half lot containing 100 acres, and section was like thousand acre sections with 20 chains into 50 chains, each containing 100 acres. This system was first township in which an attempt was made to check the survey by the means of cross ties between concessions. Not only were the center lines of the road lines between the concessions surveyed, but also the center lines of the road lines between every fifth lot, thus forming surveyed lot of 10 lots, with each section containing a total of 1,000 acres. Measurement of the land was based on the old chain and link system. A chain is 66 feet, 100 links make a chain, and 80 chains make one mile. There's also like a fractional description. As the provincial population grew, the demand for a smaller division of land increased. When another system gradually encountered more and more fractional lots. Now let's go to the important aspect of title insurance. The title insurance relates to the loss or liability for loss due to the invalidity of of a title to the property. And again, there are a bunch of important companies like Chicago Title Insurance, Canadian First Canada Title Insurance, the Lawyers Professional Indemnity Insurance, and Stewart Title Company. There are the type of policies. There are two types of policies. One is a lender policy and the owner policy. The lender policy in Ontario offers a range of policies to address these audiences, and the policy terms and coverages will vary. The structure in the form of the title policies, whether lender or owner, are more or less standardized, keeping in mind that there are separate policies that targeted to commercial and residential properties. Commercial policies follow one of the several or less standard wordings. In case of residential, the standardized basic policy have given way to various extended policy, making direct comparison more complex. So most title policies include general coverage of general statement of coverage, specific types and title risks. Let's look at the range of coverage possible. Any detailed comparison of either lender or owner policies, as well as essential or commercial packages, is quite complex. So, title risk for essential property, that's the owner policy, provides some indication of the scope of such coverage. So, the kind of coverage that's provided is a document related to the title is not properly signed, otherwise defective. The document was defective register on the title, some form of forgery or fraud happened, and inability to access the property was uncovered. The title is unmarketable. The contravention of a municipal bylaw occurred. Contravention by Office of Division Development Agreement or other agreement relating to the development of property occurred. Construction lien were discovered on the title. Other individuals claim right over the property, not identified title document. A lien on the title is discovered. Other restrictive covenants may exist, and someone else holds the interest in the title. So, what are the benefits of having title insurance? Well, the title insurance provides a mean not only to address qualification within reporting letter, but also to protect against various errors that could potentially occur through a fraudulent activity or simply errors made in the document prepared by others. Lenders, in particular, take a great comfort in the value of title insurance to address issues that might have been missed despite the diligent effort of the solicitor. So again, the kind of benefits can be grouped into four categories: surveys. So one of the attractive aspects of title insurance is the possible avoidance of a new survey. The elimination of surveys requirement can represent significant saving as well as eliminate a possible delay in the closing process. The title problem at the listing can also be solved, since sellers can take advantage of title insurance at the point of listing. For example, a problem related to the title may crop up in the listing process, where the real estate practitioner identifies a circumstance such as a decade that extends beyond the approved setback in the municipal zoning bylaw. The seller may then be able to secure title insurance and confirm that the property will be insured against any loss that may occur due to this problem. Marketing initiatives: that seller may agree to purchase title insurance as an incentive in marketing his property. Title problems: the closing title problems have proven particularly effective in ensuring over certain title policies have been effective in ensuring against certain title problems that crop up near the closing. For example, a minor encroachment may exist that could otherwise delay or cancel the sale. So those can be rectified by getting a title. So, what are the legal requirements or legal disclosure requirements? The Law Society of Canada sets out the various disclosure requirements for lawyers concerning title insurance pursuant to the rules of professional conduct. The lawyer shall access all reasonable options to assure title was when advising the client about the real estate conveyance. The lawyer shall not receive any compensation, whether directly or indirectly, from title insurer, agent, or immediately recommending a specific title insurance product. The lawyer shall disclose to the client that no commission or fees has been furnished. If discussing title plus insurance with a client, the lawyer shall fully disclose the relationship between the legal professional society and the law professional indemnity corporation. Let's look at the closing procedure. Again, in the closing procedure, there's a purchase side and there's a sale side. On the purchase side, there's a title search. Essentially, in the registry, we need to search for 40 years for search or examination of chain of title, and the land title says only current information is looked at. Items like outstanding encumbrances, estate covenants, non-resident parties, expropriation and matrimonial home status comes under the title search, and so the way title search works is a day is recorded, and then that is used for a sub search at the point of closing. Non-title search involves zoning, work orders, execution, registered easements, like a hydro easement, personal property outstanding amount like local utility charges which are not paid, status of real estate property taxes, survey documentation like setbacks, encroachment, and any such related matter or compliance with the subdivision. But again, and also status concerning the Ontario New Home Warranty Program if that is applicable. So range of non-title search varies by the property. So for example, a real property may require searches that involving the local health unit or a municipal record concerning a waste disposal system, conversion authority requirement for properties within the regulatory area, approval from the Ministry of Natural Resources under the Public Lands Act, in some instances Park Canada, in relation to federally controlled canals concerning waterfront improvements. Now there's a requisition date that is provided in the agreement of purchase and sale. The buyer may examine the title to the property at his own expense until the stipulated requisition date, which is earlier of the 30 days 30 days, which earlier of the 30 days and at the later of the execution date and the condition date, and the closing date minus 5 days. So with regards to the closing, the buyer lawyer, upon the arrival of the either land registry office where it commences a sub search, this completes the chain of title from initial search date to the closing date, including a review of the daybook of the instrument that are not abstracted. Solicitor for the buyer then meets the seller representative to compare any last minute details, providing items as requested in the closing memoranda, and discuss problems and give undertakings as required for the unresolved issues. At registration counter, the documents are presented in correct order for registration and the funds are released at the point of registration. The lawyers will provide final reporting letter after closing that includes his or her opinion regarding title, all qualification, limitations, exceptions, and provision concerning the title insurance detail, etc. On the sale side, there's a document preparation that happens. The seller lawyer prepares title, draft title or deed, and declaration or direction for transaction, and seller take, and it gives the seller take by mortgage that will also provided. The requisition letter, the seller lawyer will respond to the requisition from the buyer solicitor, providing such details are considered with the agreement purchase and sale with the time limits. It's a statutory declaration concerning not being non-resident, declaration of possession covering seller's period of ownership, direction for payment of funds, the closing seller undertaking to pay tax levies, or charges, penalties, or utility accounts and provide vacant possession, evidence of no executions, no contribution to the Planning Act, discharges of any lien, mortgage, or encumbrances, compliance of the building or the improvements with zoning bylaws, a statement certifying that the sale of the land and premises is exempt from the harmonized sales tax. With regards to document review, the seller solicitor reviews all the draft documents provided by the seller lawyers to ensure that they compliance with the terms of the agreement and discuss any items requiring clarification or resolution with the buyer solicitor. And as a part of closing, seller lawyers will attend land registry office, exchange documents with the buyer's lawyer. He typically will review any last minute details, provide items as requested in the closing memoranda, discuss problems, and give an undertaking as required for any unresolved issues. Looking at the closing statement, which essentially closing statement is a financial is a statement of adjustment, essentially a statement for preparing itemizing the financial history of the transaction, including such items as deposit, down payment, etc. Regards to the electronic closing procedures, the right now Polaris and the electronic conversion is done by two systems, Polaris and TerraView. Polaris is automated land registration system based on the land titles. Index, the description of the property ownership and property mapping, so like survey or plan database. Individual parcels have a unique PIN number. TerraView is electronic user registration gateway, which is made by available by Terra Incorporated. It is a company. The access is through a removable computer drive with individual security credentials, and for any TerraView users, the option for search, create, update, complete, or approve and release the registration of the documents. I think with this we are done with chapter 3. Thanks for your time. Bye.